आता मी विनंती करतो सन्माननीय पोलीस कमिशनर साहेबांना की त्यांनी आपल्या विषयाची सुरुवात करावी.
मंचावर उपस्थित मान्यवर आणि या कार्यक्रमास उपस्थित सर्व अतिथीगण, सर्वप्रथम आम्ही IHRCचे आणि सर्व ऑर्गनायझिंग कमिटीचे हार्दिक अभिनंदन करतो. अत्यंत महत्त्वाचे विषयावर यांनी आज इथे पॅनल डिस्कशन ठेवण्यात आलेली आहे. खरं सुरुवातीला आपल्याला याचे ठळक जे काही मुद्दे होते न्यू क्रिमिनल लॉजबद्दल ऑलरेडी सांगण्यात आलेली आहे. परंतु खरी गोष्टी आहे की कोणताही लॉ जसे एक ज्युरिस्प्रुडन्सचे एक क्लिअर हे आहे, एक प्रिन्सिपल आहे दॅट इग्नोरन्स ऑफ लॉ इज नो डिफेन्स. म्हणजे सगळ्यांना लॉबद्दल, सगळ्यांना कायद्याबद्दल माहिती आहे अशी प्रकारची प्रिझम्पशन अशा प्रकारच्या म्हणजे गृहीत धरण्यात येते. आणि खरं जे कायदा IPC असतील, CRPC असतील, एव्हिडन्स ॲक्ट असतील, आम्ही सुरुवातीपासून तीच ऐकलेले आहे. त्याचेच कलम आम्हाला माहिती आहे. 302 काय आहे, 376 काय आहे. आता आज पूर्णपणे आम्ही नवीन कायद्यामध्ये गेलेले आहे. याची अवेअरनेस, याचे काही ठळक काही मुद्दे आहे ते सर्वांना कल्पना असणे अत्यंत आवश्यक आहे. म्हणून अशा प्रकारचे सेन्सिटायझेशन कॅम्पेन आणि अवेअरनेस प्रोग्राम्स होणे अत्यंत गरजेचे आहे. इनफॅक्ट मिनिस्ट्री ऑफ होम अफेअर्स म्हणजे भारताचे गृह मंत्रालयाची पण अशी अपेक्षा आहे की मोठ्या प्रमाणात अशा प्रकारचे जनजागृती कार्यक्रम व्हावी. त्यामध्ये पोलीस, त्यामध्ये ज्युडिशरी, त्यामध्ये ॲडव्होकेट्स, बार काउन्सिल सर्वांचे सहभाग घेऊन अवेअरनेस लोकांपर्यंत पोहोचवणे अत्यंत गरजेचे अशी शासनाची, सरकारची पण भूमिका आहे. म्हणून या अशा प्रकारचे कार्यक्रमची गरज आणखी म्हणजे इट प्रूव्स हाऊ इम्पॉर्टंट सच अवेअरनेस कॅम्पेन्स आर. जशा सांगण्यात आला की पूर्वी पनिशमेंट ओरिएंटेड कायदा होता, आत्ता जस्टिस ओरिएंटेड कायदा आहे. प्रायोरिटायझेशन ऑफ laws which was explained pretty much in detail how 302 and crime against women were taken to sections much later than sections like sedition, etc. So here the new law certainly provides for prioritization of laws, and it shows primarily how important it is for all of us, especially on issues of offenses against crimes against women and children. So primarily in the new Bharatiya Nyaya Sanhita BNS, which replaces the IPC, primarily it is the punishment. Some offenses have been decriminalized, some new sections have been added. But the most important thing is the issue of compensation or issues of fine. For example, if we look at the punishment for rapes, it says त्यामध्ये fine should be commensurate with what is required for the rehabilitation of the victim and to bear the medical expenses of the victim. So the amount of fine per se is not mentioned in the punishment section of these offenses, but it takes care of the medical expenses, the medical remuneration, as well as what is required for rehabilitation. And lot of sections, the victim centric approach of the new laws is very, very important. And I'm sure in the days to come, whenever we get a chance to have first trial of such offenses completed, we are certainly, as a police department, we are certainly going to submit at the time of argument on the quantum of punishment. We in the Pune City Police are intending to try and assess the value which the victim requires both for medical rehabilitation and for her future rehabilitation. So that would be very interesting to see in the days to come, because that is to my mind one of the very, very important radical changes in the new law, apart from many others. But for the police department, the major aspect for us is the procedural law, which is BNSS, which replaces the CRPC. And here awareness on the procedural laws is very, very important, so that a victim or his or her relative who comes to the police station or who comes in contact with the police should be aware of what are the provisions of the new procedural laws, what the police can do and what the police cannot do. See, when a victim, when a firyadi, when a complainant comes to the police station, of course, his or her expectation is that police should have a miracle stick and the criminal, whoever he is, should be punished. Of course, if there is an incident which to our mind, which as per law is a minor offence, whether I have a fight with a neighbor and he pushes me or my relative, I would certainly get agitated, and if I go to the police station, I would expect that the person who pushed me should be behind the bar, should be taken, immediately arrested. He should be put inside the jail, he should not come out, and he should remain in the jail for quite some time. This is a normal expectation which every victim would have. But what is more important is that we have to realize that it is outside the powers of the police to actually arrest someone in offences which are lower than a certain level of gravity. For example, in the new law, it is very, very clear that offences which are punishable for less than 7 years, the police does not ordinarily have powers of immediate arrest. And that is one of the primary reasons, the powers of arrest, the expectation of a victim that we would act immediately. We would register an offence immediately and we would arrest the accused immediately and put him in jail for a period, to a longer period. This is the expectation which the public has vis-a-vis the powers which the law gives to the police, which leads to a sort of a mismatch, a sort of a disequilibrium between the expectations of the public and the powers of the police, which primarily, to my mind, is one of the major reasons for a sort of a not so good image. I would not say a bad image, because what image used to be bad around 20 years back, I think we are on a much better footing today. But not so good image, I would certainly say. And there again, the awareness is very, very important. People should know what is a cognizable offence, what is a non-cognizable offence, what is an offence where we have powers to arrest, what are offences where we do not have powers to arrest. Now one must realize that if you have in mind that why is there the new law contains provisions that if there is an offence punishable less than 7 years, police should not arrest. One must realize that primarily liberty of an individual is a fundamental right which every individual has. So this provision in the law is a very, very well thought of provision which is in consonance with what the courts, including the highest courts, have been talking various case laws, that the liberty of an individual is a fundamental right which should not be compromised except with due procedure of law. Of course, the procedure is that if you have committed a heinous crime, of course you have to be inside. But if there is a minor offence, if there is a petty offence, abridging someone's liberty, certainly cannot be a police power, because we also as leaders of the police force realize that while it is our duty to prevent law and order or prevent ruckus or maintain public peace and order, yet the taking away of liberty of an individual is something much larger than this, and the liberty cannot be restrained, and that is the reason why such provisions find mentions in the law. As an individual also, for example, in the Porsche case, in the infamous Porsche case of Pune, I would not go into the subject of juvenile, but I would go into the subject of the other accused, including the parent, the father, the mother, the doctors who are inside the jail for now more than 60 days. Now, we are making all out efforts to ensure that these people should not come out on bail. Having said that, the point is that at some point of time, of course, subject to our, we are obviously contending that we want them to be in jail till the trial finishes, because it's a very, very heinous offense. But it's a question. I don't know how it is a question of whether we are able to convince the judiciary appropriately or not. But the fact is that for any offense, finally an accused has to come out on bail. We as police officers cannot take a stance, and even if we take it, the judiciary doesn't consider it, that त्याचे परिणाम कायदा सुव्यवस्थावर होईल किंवा public peace and order वर होईल, to control, to maintain law and order and to ensure that there is no disruption of public peace and order. We have other detention laws, which is not these penal offences. They are detention laws. We have the MPDA. We have the preventive sections in the BNSS. Earlier the preventive sections, the powers were with officers of the rank of ACP. Now it has gone up to the level, to the rank of DCPs or SPs, and that too because there has to be application of mind, because again, on a preventive detention law, we are again restraining the liberty of an individual. Hence, liberty of an individual is paramount, and this has again been recognized in the law. And we have to create awareness that so that the bridge between the expectation of the public and the powers of the police, if we are able to bridge that gap, it would go a long way in trying to meet the aspirations of the public. The people will have confidence in the criminal justice system, in the law enforcement machinery, and that's why again provisions like this, which has come in black and white in these new laws, are very, very important. The recognition of digital evidence, the recognition of technology, the recognition of evidence-based criminal justice system has been recognized in this in the Bharatiya Sakshya Sanhita, which is again very, very important. Now the law provides that for any offence which is more than 7 years, punishable for more than 7 years, you have to have forensic examination is mandatory. There are the audio and the video recording of the evidence has to be done. It has to be expeditiously submitted to the court of law. The idea is that the recognition of technology is again very important, and it will go a long way in trying to have quicker justice, speedier justice, and probably convincing the courts, that the concerned trial courts, about the culpability, about the evidence which we have against the accused, because that is again very, very important. The increasing of conviction rates is one of the issues, which is one of the challenges which we are facing today. We and the prosecutors, we jointly have this issue. At one point of time in 2008, the conviction rate of Maharashtra had dipped to as low as 8%. Meaning that of the 100 accused we are arresting, only 8 get convicted. And this figure, of course, due to efforts which were taken subsequently, today we stand at around more than 40%. That's a much better figure, but ideally the figure has to be much more than that. Here again, so technology and digital-based evidence, for use of forensics, use of mobile phones for recording of evidences is again very, very important, and this has been recognized in these acts. There are plethora of new initiatives which has been taken by the new government. I mean by the government. I mean, even though it is 75 years after independence that we had a new law, there is a criticism by certain people that it's a old wine in a new bottle and things like that. The point is that, of course, while transiting from the earlier laws, we cannot say that they were totally useless, because it has, apart from certain sections which were totally unwarranted in the post-independence era, we have gone through that, gone along that act for some time. But now it was time that we needed a complete revamp of the system, and it has come in. I'm sure it's in a transition phase, and to have all the provisions and all the ideas which the legislators had crystallized into practicality, it's going to take some time. But yes, I can say that the police department is thoroughly geared up to try and enforce these laws with full force. And just to inform you, just to clarify one point, that you have to realize that 1st July 2024 is the cutoff date. So any offence which took place before 1st July, since there are the criminal jurisprudence, the jurisprudence says that there is no retrospective effect to a law. So since it came into effect on 1st of July 2024, any act which took place before 1st of July is still going to be punishable under the old law, even if it was registered or unregistered. So if an offence happened on 29th of June and it gets registered today, it will be registered under the earlier section of law. And in that, however, since it is registered after 1st of July, the procedural law would be the new law. So the procedural law would be the Bharatiya BNSS. So if an offence took place before 30th June and got registered before 30th June, it is IPC and CRPC which is valid. If it happens before 30th June but gets registered after 1st July, it is IPC and BNSS. And if act takes place after 1st of July and gets registered after 1st of July, it is BNS and BNSS. So here in this transition phase, both these laws are at times going to come into play, and the most important point which the law basically provides for, and we expect it to happen over a period of time, is speedy justice. There is a time frame which has been given in the law, first time in the law itself, that there is a time period between which since the registration to the trial and to the appellate to appeal has to end in a particular time period. Because to my mind, it is the issue of volumes, it is the issue of pendency in the courts and at the police station which is leading to slower justice. And of course it said justice delayed is justice denied. So primarily once it happens within a period of time, because if it is delayed beyond a particular time, you would realize that the person who investigated would have already retired. He would have lost all his, whatever he had done, it would not be in his memories. The interest or his commitment to ensure that what he investigated the accused has to be punished, maybe that dies down. Hence, it is very important that the backlog in the judiciary, of course, they are taking steps to reduce the pendency, but the justice in a particular time frame is going to be very, very important. There we would be able to improve on the conviction rate also, and of course, get the victim appropriate justice. So that's again a very, very important provision of law. Once again, I thank the IHRC and all the members of the organizing committee, and especially Mr. Naveen Naidu who invited me for this and gave me an opportunity to be a part of this discussion. Thank you very much.